Did the way the Wisconsin Labor and Industry Review Commission and the decision of the Wisconsin Supreme Court violate the First Amendment? Reading from the opinion, the First Amendment mandates government neutrality between religions and subject any state-sponsored denominational preferences to strict scrutiny. Actually, that's not what the First Amendment says. It reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So the First Amendment does not mandate general government neutrality, but that Congress not get involved in religion. Congress cannot establish a religion nor regulate religious practices. But the First Amendment specifically states this limitation is on Congress. Now, that's not to say that Wisconsin's actions do not violate the Constitution, both of the United States and the state of Wisconsin. Let's start with the Constitution of the United States. Under the 14th Amendment, we read, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor deny to any person within its jurisdiction the equal protection of the laws. The decision of both the Labor Board and the Wisconsin Supreme Court violated the Equal Protection Clause of the 14th Amendment. Reading from the opinion, the Wisconsin Supreme Court's interpretation of 108.0215H2 imposes a denominational preference by differentiating between religions based on theological lines. Petitioners' eligibility for the exemption ultimately turns on inherently religious choices, namely, whether to proselytize or serve only co-religionists in the course of charitable work, not secular criteria that happen to have a disparate impact upon different religious organizations. Because that regime specifically differentiates between religions based on theological practices, strict scrutiny applies. So Wisconsin protects some religious organizations, but not others. That's the definition of denying the equal protection of the law. Now, if that's the United States Constitution's view, what about Wisconsin's? If it prohibits giving preference to religious establishments or modes of worship, isn't that exactly what both the Labor Industry Review Commission and the Supreme Court of Wisconsin did?